Good day, I am Reynalyn Hart Ramas from BSA 23, and this case is about Buenaventura Angeles et al., which is the plaintiffs and appellees, versus Ursula Torres Calasanz et al., which are the defendants' appellants. Facts. The plaintiffs' appellees filed a suit against defendants' appellants claiming that the final deed of sale should be in their favor after discovering that they had already paid a total of 4,533.38 pesos in interest, real estate taxes, and incidental expense for the registration and transfer of the land. The plaintiffs and appellees, who deposited a down payment of 392 pesos at the contract's execution, agreed to pay the remaining balance in monthly payments of 41.20 pesos on the 19th day of each month until the contract was entirely paid. The plaintiffs' appellees made monthly installment payments until July 1966, 4,533.38 centavos. On December 1966, the defendants or appellants sent a letter to plaintiffs' appellees requesting payment of past due debts, and on January 28, 1967, they dissolved the contract due to the plaintiff's failure to make future payments. Additionally, the defendants have refused the plaintiff's letter for reconsideration of the cancellation. The defendants' appellants asserted that the plaintiffs' appellees violated paragraph 6 of the contract by failing and refusing to pay or offer to pay the monthly installments beginning in August 1966 for a period of more than 5 months, obliging the defendants' appellants to cancel the said contract. The lower court granted judgment in favor of the plaintiffs' appellees and determined that the defendants' cancellation of the contract in this instance was not legitimate. As a result, the court has ordered the defendants to complete a final deed of sale in the plaintiffs' favor, after their petition for reconsideration was refused. The defendants' appellants assert that the contract was legally terminated pursuant to paragraph 6 of the contract and contended that the certain provisions of the contract related to Article 1191 were breached. The issue is whether or not the defendant's appellant's contract to sell to the plaintiff or appellees was automatically and lawfully terminated. Proceeding to the held disposition of the case, wherefore the instant petition is denied for lack of merit and the decision on appeal is affirmed, with the modification that the plaintiff's appellees should pay the balance of 671 pesos and 67 centavos without interest. The dictum, according to Article 1191 of the Civil Code, the right to rescind obligations is implied in reciprocal ones in the event that one of the obligors fails to perform his obligations. The injured party may choose between fulfilling the obligation and rescinding it, with the payment of damages in either case, although the defendant's allegation of breach of contract against the plaintiffs is relatively little due to the plaintiff's payment of monthly payments for nearly 9 years. The plaintiff can pay the whole obligation in a reasonable period of time. However, defendant's allegation of breach of contract is trivial in view of the fact that the plaintiffs paid monthly installment for over 9 years. According to Article 1234 of the Civil Code, if an obligation has been substantially fulfilled in good faith, the obliger may recover as if it had been strictly and completely fulfilled minus the obligee's losses. And that's all for this case.